Hello and welcome to Verdictum. I'm Sheetal June and you're watching today's legal news where we update you with the latest legal developments across the country. Starting with the headlines. Kolkata doctor rape and murder case. SC Suo-Moto constitutes task force for safety of doctors across the country. Google must face class action lawsuit over Chrome's data collection, US court. Supreme Court dismisses Calcutta High Court's controversial verdict advising young girls to control sexual urges. SC/ST organizations organize Bharat Bandh to protest recent Supreme Court ruling on subclassification in Quota. Now the news in detail. The Supreme Court, while hearing Suo-Moto plea in connection with the case pertaining to rape and murder of postgraduate junior doctor at Kolkata's R.G. Kar Medical College, expressed deep concern that the victim's photograph and name has been made public. Stating that the law strictly prohibits the same, CJI Diva Chandrachud stressed that those involved are lowering the dignity of a young victim who tragically lost her life. A three-judge bench, also comprising of Justice J.B. Pardiwala and Justice Manoj Mishra, stated that the top court took Suo-Moto cognizance of the case as it raises a systemic issue regarding the safety of doctors across India. The CJI stated that if women are not able to go to work and conditions are not safe, we are denying them equality. As more and more women join the workforce, the nation cannot wait another rape for things to change on the ground, he said, adding that the existing laws do not adequately address the institutional safety standards for doctors and medical workers. The court rebuked the West Bengal government for failure to maintain law and order and protecting the crime scene and asked it to refrain from unleashing the power of the state on the peaceful protesters and others commenting on the incident. The court ordered that CISF be deployed at the medical college for safety reasons. Majorly, it has directed to form a 10-member national task force to make recommendations on prevention of violence and safe working conditions for medical professionals. The task force shall look into the safety, well-being of medical professionals and other cognate matters highlighted. The NTA shall consider preparing action plan to prevent gender-based violence, prepare national plan to prepare dignified working of interns, resident and non-resident doctors. The court has also urged the protesting doctors to resume work as it affects the patients to avail health-related services while assuring them that their concerns are receiving the highest importance before the top court. It has asked the CBI, which is probing the case, to file status report by August 22nd, when the court will hear the matter again. A US appeals court has ruled that Google must face a renewed lawsuit from Google Chrome users who claim that the firm obtained their personal information without their permission after they refused to synchronize their web browsers with Google accounts. The 9th US Circuit Court of Appeals in San Francisco said that the lower court judge who dismissed the proposed class action should have considered whether reasonable Chrome users agreed to allow Google to gather their data when they browsed online. The 3-0 judgment came after Google agreed last year to destroy billions of information to resolve a complaint alleging that the Alphabet business traced consumers who believed they were browsing quietly, including in Chrome's incognito mode. The suggested class includes Chrome users who have not synced their browsers with Google accounts since July 27, 2016. They claimed Google should have followed Chrome's privacy notice, which stated that users do not need to provide any personal information to use Chrome and that Google would have not received such information unless they enabled the sync feature. The lower court judge decided that the Google's journal privacy policy, which permitted data collection, applied because the Mountain View, California-based business would have collected the plaintiff's information regardless of which browser they used. The Supreme Court has set aside the controversial order of the Calcutta High Court whereby it acquitted an accused in a sexual assault case while making objectionable and controversial remarks advising adults and girls to control their sexual urges. A division bench of Justice Abhay S. Oka and Justice Ujjal Bhuyan said that such observations are shocking and perverse and noted that a judge has to decide a case and not preach, and his or her personal opinion cannot be made a part of the judgment. The High Court went to the extent of observing that the case of criminalization of a romantic relationship between two adolescents of opposite sex should be best left to the wisdom of the judiciary. The courts must follow and implement the law. The courts cannot commit violence against the law, the bench said. Observing that brevity is the characteristic of a quality judgment, it stated that a verdict must be clear, simple, and not verbose, and an order is not a thesis or a piece of literature. We need not waste pages dealing with every observation or finding quoted above. The observations are utterly irrelevant for deciding the controversy. To say the least, these observations are shocking, which will ex officio invite a finding of perversity, the bench said. The Supreme Court stated that it is the state's responsibility to care for the defenseless victims of such horrible crimes, and the court has repeatedly declared that the right to a dignified existence is an essential component of the fundamental right provided by Article 21 of the Constitution. The National Confederation of Dalit and Adivasi Organization (NACDAOR) today called for a one-day Bharat Bandh or nationwide strike to protest the recent Supreme Court ruling on the subclassification of backward classes within the reservation system. NACDAOR has invited members of scheduled castes, scheduled tribes, and other backward castes to join the peaceful agitation to reinforce their case for better representation and protection for marginalized communities. In the ruling, a 7-judge bench led by Chief Justice D.Y. Chandrachud held that the subcategorization and subdivision of the scheduled caste and scheduled tribes are permissible, has held that for benefit of the affirmation action, the creamy layer should be excluded from the reservation given to SCs and STs. It thus allows states to create additional subclassification within the SCs and STs to guarantee that the benefits of the reservation reach the final mile. The NACDAOR has urged the centre to reject the ruling, arguing it threatens the constitutional rights of the SCs and STs. It has called for the enactment of a new Act of Parliament to address the reservations for SCs and STs and OBCs. They demand that this Act should be included in the 9th schedule of the Constitution to shield these provisions from judicial interference. Among other demands, they also seek recruitment of judicial officers and judges from all sections of the society to achieve 50% representations of marginalized communities in the higher judiciary. That was all on today's legal news. Thank you and keep watching Verdictum. Subscribe to our channel and download the Verdictum app on iOS and Android devices for latest legal updates.